Hi, I'm Paul Vacheski. I'm the director of Randall School of Real Estate, and we're starting a new series of videos called Nebraska Landlord Tenant Law. Today's lesson, we're going to be dealing with notice requirements. This comes from Nebraska Revised Statute 76-1413. Now, we're not going to be talking about the specific notices themselves. That will come in future videos. Today, we're just going to be talking about the process of giving notice and receiving notice and what the statute says. Quickly, before we move on, please read the legal disclaimer there. No part of this presentation is legal advice. It's all for informational purposes only. If you need an attorney, please hire one. All right, let's move on. Before we get going, I want to orientate you to the different types of notices that are allowed under the landlord-tenant statute. The first one is the 3-day notice. The 3-day notice is the landlord delivering a 3-day notice to the tenant. This is for non-payment of rent only. The 30-day notice, that's basically for any violation of a lease or a law, an ordinance, a rule that's non-rent related. This notice can be served by the tenant or the landlord. One of the 5-day notices the tenant delivers to the landlord. This happens when maybe the landlord and tenant agreed that this apartment will be ready on October 1st and it's not ready on October 1st, then the tenant would deliver a 5-day notice of noncompliance. There's another 5-day notice called a clear and present danger. That's the landlord delivering this notice to the tenant. And then lastly, the 30-day notice is for changes in rules, ending tenancy, those type of things. And it's available for the landlord or the tenant to serve on one another. Now, we're not going to discuss these today. I just wanted to orientate you to them because what we're talking about in this lesson today is the legal process to deliver one of these notices. So 4 areas I want to talk about today as we discuss the notices. What is proper notice? What is giving proper notice? Sending and delivering proper notice, and receipt of proper notice. There's 3 aspects of the notice that we have to know. The first is the parties. The landlord and or the tenant can send this to one another. The other part is one of those parties are going to receive the notice, and the third is ensuring the required time frames are met. Now, a few of the notices do require specific formats. They have to be in a certain format. We're not going to talk about that today. That'll be relative to the individual notice that we're going to discuss in future videos. So let's start with giving proper notice. Some notices have to be in writing, some don't have to be. Notices that are considered triggers have to be in writing. For example, if you're behind on your rent, I just cannot evict you. I have to give you legal notice that says you have 3 days to pay the rent or I'm going to evict you. It protects your interest and your rights, and it goes both ways. So if the landlord's in breach, the idea is that the tenant's going to serve the landlord the proper legal notice to say, hey, knock it off, comply with what we agreed to, or through constructive eviction, I'm going to move out. Verbal type notices are valid for certain things. However, from a risk management point of view, I always recommend every notice be put in writing, no matter how minor you may think it is, just simply for documentation purposes, should you need to document things for future legal action. All right, next, what does the statute say about delivering? How do we deliver these notices? So, under the statute, we're allowed to deliver notices to one another either by hand delivery or by mail. Hand delivery, let's talk about that. The way we hand deliver is exactly how it's implied. We knock on the door. Here is your notice. We hand deliver it to the occupant of the dwelling. If the tenant isn't home, then what we do is we tape the notice to the door, and it is recommended that you take a photo of that notice hanging on the door with your cell phone or your camera in case we need it for future reference to prove that you served notice by hand delivery. The second way is by mail. Most of the time we feel that we should probably send these notices via mail by certified or registered mail. That is not correct. Keep it simple. We only need to deliver it by first-class mail. In fact, if we deliver things by registered or certified mail, we are voluntarily agreeing to a stricter notice requirement. So if I'm the landlord and I send my 3-day notice for non-payment of rent to the tenant, and I send it by certified mail, the post office is going to notify the tenant that there's a registered mail, a piece of registered mail that's sitting at the post office and they need to come sign for it. Well, if they know they haven't paid the rent, they're not going to go to the post office and pick it up. So if you try to evict them, they're going to be able to claim that, hey, I never properly received the notice because we voluntarily agreed to a stricter notice requirement. Send it first class mail. All right, vacated properties. Just because the tenant moved out, let's say that the tenant didn't pay November's rent and they moved out, but they still owe for the month of November. They're responsible for it. Just because they vacated it doesn't remove the landlord's requirement to provide proper notice. One of two ways: we either send it to them or we hand deliver it with the same way that as we previously discussed. Hand deliver it, they're obviously not going to be home, so you got to tape it to the door and take your photographs. Or you send it first class mail to the last known address, which is usually the rental property. So again, the courts say that this is sufficient for proper service of notice by simply sending it first class mail. Let's look at receipt of proper notice. It's been my experience most of the major points of contention between landlords and tenants is when the notice was sent and when it was received. Most tenants, they actually think that if they didn't receive the actual physical copy of the notice that they can't be held accountable for it, and that's simply not the case. Physical proof that the tenant received the notice is not required. Okay, we've discussed this previously. In the case of the landlord is considered in receipt of the notice when it is hand delivered or mailed to their place of business. Now, if their place of business, they don't have a place of business, maybe it's their home or whatever the case may be, it's not clearly identified in the lease, then it's considered under the statute their place of business is the lease, where the lease agreement was signed by the parties. All right, so here's my recommendation. Landlords ensure that addresses and locations are specifically noted in the lease to where tenants need to deliver their notices to. So there you have it. I hope this video has been helpful to you. If you have a question, please leave a question in the remarks section below, and I'll answer any questions that you may pose to me. Leave a comment, and please be sure to subscribe to my channel. This will ensure that you receive notice of any future videos, and there's going to be several of them, particularly on this topic.